Ms. Hackle,
Hi. Hello. The authorized representative for Hackle is here.
please turn your camera on, please.
Okay, I have to access it, so it might kick me out. So I'm gonna do it now.
That's fine.
Okay.
I know I denied the motion to set aside the default judgment back on August 21st. Defendant failed to appear.
Correct.
Defendant's motion to seek leave of court is denied. Um,
We're showing a current, although this is a termination of tenancy for failure to recertify, we show a balance of in excess of $12,000.
Ms. Hackle, state your name for the record.
I am the authorized representative for Alicia Hackle.
I don't see your face. I'm sorry. I see your hat. Let me see your face.
Oh, okay, I'm here.
The camera. The camera's pointed at the top of your head. I can't see your face. All right. Mr. Hoop, go ahead.
Yeah, thank you, Your Honor. A judgment was entered, a motion was denied, trying to set aside the judgment. Plaintiff is seeking a order of eviction for termination of tenancy. No payment has been made since March of 2024. We would ask that a writ be issued.
So the writ will issue and execute immediately.
Thank you, Your Honor.
I would like to say
Thank you.
there's been a defective order of process.
All right, folks, buckle up, because today we are diving headfirst into the wild world of sovereign citizens in court. We got three absolutely unbelievable cases lined up. First, a representative of sovereign squatters who clearly thinks normal court rules don't apply to them. Second, a right-to-travel follower who hits reality hard when he realizes turning back to the system costs him barely anything. And last, but definitely not least, the grand finale, the most epic sovereign citizen shut down by a judge I've seen in ages. Stick around, because the twist, the drama, and the jaw-dropping moments start right now.
I've actually never received that so that I could formally respond to it.
All right, so let me make a record. Give me 1 second.
Yeah, there should be some proof of service in the files for the case.
Well, hold on 1 second. 1 second. You were
Okay.
served with the summons and complaint. It was posted on the address by Chief Officer, Court Officer Juan Polanco. I believe he did it on July 20th, 2024. And then there was a default judgment entered against you by Judge Goubeau on July 31st, 2024. I believe you failed to appear. You didn't appear to that. And so that's how we get here now. Then you filed a motion to set aside the default judgment. Hold on 1 second. And you did not appear to the default judgment. So yeah, the writ in issue. So you've been advised of court and you failed to appear twice. Like I'm not understanding what's going on.
I actually
so the
all my documents. I've given all my documents. There was a judgment issued against me. And it was denied. But and then after that, I hadn't received anything back for the case until I'm in court today about something that I had gotten no prior documents before I came to court today. I literally didn't receive any motion for issuance for a writ until today when I went to the court to get the papers. I didn't receive this by mail at all, so that I would have been able to respond to it before now.
Your Honor,
I have not missed any court dates.
Your Honor, I heard your ruling. Thank you very much.
All right. Thank you. We're all set.
Have a good day.
You too. Thank you.
Here's the first red flag moment. Our defendant thinks missing hearings somehow makes the court powerless. But as we see, judges don't just roll over. Notice how the court immediately references the prior default judgment and the motion denial. This is classic sovereign citizen behavior. Argue procedural technicalities while completely ignoring the fact that the system has already moved forward. The drama builds because now the representative is caught in that awkward position. Try to act as the voice of the evicted while clearly not following protocol. Watch carefully because this pattern is going to repeat throughout the cases.
If you change your mind and you do want to come back and ask for an attorney, just come back and let me know, okay?
Okay. Before I get into the breakout room, Your Honor, I do want to address we are in the pretrial stage, and in the arraignment stage, I was entered a plea involuntarily. So I would love to have an ample amount of time to draw a meaningful defense. If anything, there was some questionable things that the last judge mentioned that I haven't found at all as far as a statutory jurisdiction. But I would like to have time to draw a meaningful defense as well.
Okay, so do you not want to meet with the prosecutor then?
Well, I don't think it's completely prudent right now, simply because we haven't technically went past the arraignment stage of this process. I feel as if my due process has been violated. Fifth and 14th Amendment. I didn't enter a plea, and here we are in pretrial. So I would like to kind of digress a little bit and have at least enough time to develop a meaningful defense.
Okay, I guess I'm a little confused. So you had an arraignment date, and
Yes.
at that arraignment date, did you refuse to enter? Did you refuse to enter a plea? Because that's the time where a plea of some sort has to be entered. So at that point in time, did you, of your own volition, say, I'm not saying anything at all?
Well, that wasn't totally the case, but I didn't have understanding of what court I was in, and I didn't understand if it was a criminal jurisdiction, civil jurisdiction, and based on the at least the federal laws for sure.
And there it is, the classic sovereign squatter tactic exposed. These individuals often occupy a property, claim residency, but then refuse to pay rent. Here, the judge cuts through all the smoke and mirrors, pointing out the reality. The landlord has a contract with the legal entity, not the mythic straw man. This is where drama meets education. The audience sees firsthand how the law handles people trying to exploit loopholes that don't actually exist. It's also a little bit satisfying to watch the tension deflate, as the procedural reality finally wins over theatrics.
Of our, like what court it is, what magistrate, like all that's contained in there. So I just, how did you know otherwise?
No, I did receive a ticket, and I got notice. But what my issue was appearing here on special appearance today, and I needed to get understanding of what jurisdiction I was in.
Okay, all right. So because I definitely want to make sure that people know where they're supposed to be. So I think I'm looking at the same ticket that you had. So it says on the ticket, 44th District Court, Royal Oak, and then the court address is on there. And then you said that you received notice. So the notice that went out, it would have had the Zoom instructions. Again, Mr. Myrick, as you can imagine, we are, I'm always very concerned in making sure people have the proper notification and all of that. So it does appear that, I mean, you're here a second time. The only thing that I was, now looking at the file here, you were ordered to post a bond and you didn't. Now, that was, I'm reading the notes here. It says there was a bond of $1,000 cash surety, no 10%. So $1,000 bond was expected to be paid within 48 hours. Now, Mr. Meyer, we're here today. You showed up on time. So one of the reasons that a bond is ordered is, one, for the safety of the community, and two, to a secure appearance. Well, you come here a second time, and so I am very comfortable that you are going to continue to show up. So I, at the very least, for you, Mr. Myrick, today, as long as you continue to abide by the expectation that you'll show up, and you have twice now, I'm going to actually amend that bond. So that even though you were supposed to do
Thank
it
you,
within
Your
40 hours and you didn't, okay, the fact that you showed up here again, at least to me, is enough evidence to suggest that I can count on your appearance going forward. So
Now watch this. The second case dives straight into the chaos of sovereign citizen logic. Mr. Myrick refuses to enter a plea, claiming he doesn't understand the court's jurisdiction. But let's be real. This isn't quantum physics. It's a court explaining civil procedure. The judge has to navigate carefully here, balancing patience with authority. What makes the scene fascinating is the cognitive dissonance. Myrick thinks he's challenging the system, but in reality, he's just slowing down his own case. For viewers, this is a perfect example of how misunderstandings of the law can escalate into full-blown courtroom theater.
To the challenges of the Metro Detroit area and public transportation issues and people's ability to get around, and how many people over time have got themselves in the cycle of they have to drive, but they pick up a ticket and they can't pay that ticket, so the license gets suspended and they get stuck in the cycle forever and ever and ever. Okay. Well, in our Operation Drive program, what we've done over the last, now we're in the last 8 to 10 years, we've keeping stats since March of 2016. So in the last 9 years, we're over 1,700 licenses restored. So like that's something that we try to do, is make sure that we inform, educate, get people the information that they need, which, Mr. Myrick, you could probably imagine, for years and years, the court system hasn't been great about letting people know even where to start, how to get their license. So
Yes,
in
sir.
the meantime, while you're doing your investigation, I at least want to let you know what's on your record so that you can at least know, because some people don't even know like where to start, how to go, or what to
Yes, sir.
do. And the
And
law
I
has
greatly appreciate you.
and the law has changed in a significant way. It used to be that every single little ticket that you'd get would suspend your license. Now it's only a couple tickets here and there that do that. So
I'm very honored, Your Honor, to be in your courtroom. I think you're the one that I've heard so much good news about, goodwill and good-hearted judge that assists.
Here's the brilliant part. The judge isn't just punishing, he's strategizing. The bond wasn't arbitrary. It's designed to ensure future appearances and public safety. And despite Mr. Myrick's insistence that no court has jurisdiction over him, the simple act of showing up a second time demonstrates compliance. The commentary here is key. The legal system isn't a maze to trap people. It's a framework to encourage responsibility. It's also a subtle yet satisfying reveal for the audience. Watching someone so resistant gradually align with reality, even if it's under duress, makes the drama all the more engaging.
45. Okay. Worst case scenario, they'll want the $45 on each of the old tickets. So 135. So best case scenario, 45, worst case scenario, 135. But that's Allen Park.
Wow, that's great.
And that's 24th District Court, sir, if you're looking it up.
24th District.
And it's interesting because these are very old cases, but the close date on the third ticket is 2017. And now I'm getting error readings. So, but there's just 3. Looks like you had your bond taken on the no proof because perhaps you didn't go back, and that may satisfy that.
All right. So Mr. Myrick, so here's what we're going to do. I'm going to bump this out a couple weeks. You get to work chopping away at that kind of stuff. But I will say this. I only want to bump it out a couple weeks because if you get those things done, all right, I want you to come back and see me. We'll be able to run a new driving record. We'll see if by doing that, all right, that they follow through and let the Secretary of State know. Because if they take your money and they don't let the Secretary of State know, then the suspensions remain. And then we can even contact the Secretary of State and just make sure that they know, like, oh, by the way, he paid those.
Right.
And then when you come back here, you can give me an update. But just know, if you've paid those 2 tickets, you should be able to go to the Secretary of State and pay the reinstatement fee and go from there. So what do you think? A couple weeks?
Safely to say, I would say 30 days. If I can have the grace.
No problem. No problem.
Thank you, Your Honor. I appreciate you dearly too. Thank you very much.
You're welcome. All right, so we'll adjourn this 4 weeks, and we'll send notice again. And then just do me a favor, Mr. Myrick, if you run into issues, I'm gonna send you our direct line here at the court.
Thank you very much, Your Honor.
And for example, if you do decide, if you're running into issues, I certainly can connect with Mr. Angot, Ms. Chappelli there. Mr. Angot's our MIDC coordinator. I know that you initially were not inclined to go with assigned counsel, but what Ms. Chappelli's doing today is exactly what would be done. So if you just reach out to us, let us know, like if you're running into brick walls and you say, like, I would like an attorney attached to this case.
And let's pause for a moment. This is courtroom gold. The judge's patience is being tested. Yet Mr. Myrick is blissfully unaware that his logic is essentially Newtonian physics versus a toddler's logic. The commentary here is where we add humor. Yes, he's serious about Fifth and 14th Amendments, but the reality is he's debating procedural nuance in a system designed to handle precisely this type of confusion. It's a subtle lesson for viewers. The law works, even when confronted by the most creative arguments. And it's entertaining, because watching someone wrestle with reality while clinging to fantasy never gets old.
Mr. Hart, this is not a complicated process, and this process does not get less uncomplicated. When I call a case, I start by identifying the parties that are to the case. When I'm confident I have the correct parties to the case, I proceed then and decide how to go forward. In this case, your difficulty, and I think intentional difficulty, is affecting the ability of the court to be able to proceed and to conduct its business. That's relevant to a lot of points, but most importantly, it's relevant to a pending motion that your attorney filed, presumably on your behalf, but I sense that it's not only on your behalf, it's also on your attorney's behalf. And so we're going to take up that motion, but your difficulty in basic things like telling me whether or not you're the party to a case is thwarting the court's ability to timely get its business done. I'm turning to the motion now that's before the court today, which is a motion to have attorney withdraw and to have you represent yourself, Mr. Hart. The court does not find that motion to be well placed, and I'm not going to prevent it. And the reason is there are several steps that need to be taken in order for you to be able to assert your right to represent yourself. First and foremost, I must find that your assertion of that right is unequivocal. I don't have that. What I have is your attorney's motion. And I recall very clearly and plainly the last couple of hearings that we've had. A couple of hearings ago, I had findings that I made based upon a competency and criminal responsibility examination. You were found both competent and criminally responsible by the court after assistance from the Center for Forensic Psychiatry and after an in-depth intervention and interview by them. I made the findings, your attorney agreed with them, and the prosecutor agreed. I have not once heard you make any type of unequivocal request at all. What I instead heard when I consider whether or not there's an unequivocal request for you to represent yourself is your attorney explained to me, I think this was 2 or 3 hearings ago now, that he was somewhat conflicted. And these are not his exact words, but this is what I recall from it. He was somewhat conflicted. You had wanted him to file various different motions which the attorney did not find were supported by law.
Now here comes the ultimate facepalm moment. Mr. Myrick suddenly realizes that all his elaborate sovereign citizen theatrics could be resolved for barely $50. That expression says it all. Shock, disbelief, and maybe a little regret. This is a perfect teaching moment. Sometimes the law isn't about oppression. It's about simple processes that restore people good standing. It's also peak drama for the audience. The tension is released in a single, almost comedic revelation. And the lesson? Fighting reality costs far more in stress than just doing the right thing from the start.
And so the request to have you represent yourself as made through your attorney is not found, number one, by the court to be unequivocal in any way. Number two, I would have to go through with you and be confident that you understood the maximum penalties associated with the crimes. I have every reason to believe that you understand the maximum penalties. But I have every reason to believe that if you and I had a discussion about what those maximum penalties were, you would express confusion and you would not express a knowing, confident, and voluntary understanding of those things. And so I'm not yet even going to get to that second step. I also, of course, would have to, under People versus Anderson, the binding Michigan Supreme Court case regarding waiver of constitutional right to represent yourself, I would have to make specific other findings. And those findings specifically are that I would have to determine after a conversation with you that you acting as your own attorney would not disrupt or unduly convenience or burden the court in the administration of the court's business. What is plain, obvious, and unarguable in over the last 2 or 3 hearings is that if you were permitted to represent yourself, you would make the court's administration of justice difficult. You would delay matters, you would be disruptive, and your representation, therefore, of yourself would be unduly inconvenient to the court and the court's operation of its business. For that reason, even if I found that you otherwise made an unequivocal request, which you haven't, even if I found that you clearly understood and you expressed your waiver knowingly, intelligently, and voluntarily, the court would still not grant your request through your attorney to represent yourself under specific circumstances here. It's my firm finding, based upon the background that I'm aware of, that to allow you to do so would only encourage you to file what are very spurious and frivolous motions. It would waste the court's time, it would waste the prosecutor.
So what did we just witness? Across all 3 cases, the judges handled everything from evasive tactics to outright denial of legal reality with patience, precision, and clarity. We saw default judgments enforced, bonds explained, and a classic $50 reality check that even the most confident sovereign citizen couldn't escape. The takeaway is clear. Understanding the law, following procedures, and showing up matters more than theatrics or myths. If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns of courtroom chaos and legal drama.